Articles 131 to 139, which define that jurisdiction. Please mark, my lord. Article 32 provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right by being included in Part 3. This court is thus constituted the protector and guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid upon, refuse to entertain applications seeking protection against infringement of such rights. No similar provision is to be found in the Constitution of United States, etc. Lord, here the officers are also before your lordship seeking their Article 21 rights, because there are FIRs filed by the local police, and they are threatened with, my lord, their freedom under Article 21. Apart from, my lord, my jurisdiction, my lord, on behalf of the victims of money laundering, my learned friend.
Kindly have a look at Article 226, sub-article 4.
226.
226, sub-article 4. The power.
Yes.
The power conferred on the High Court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of under Article 32. So this, according to me, is the issue. 32 powers are protected even under 227, as by the Senior Solicitor General has said, it itself is a fundamental right. There have been cases where your lordships have transferred investigation to the CBI and exercise the powers under Article 32. I may give one or two judgments by way of illustration. I see. Kindly have a look at para 80. And 82.
Para 80.
80. This has been done in exercise of powers under 82. I may just leave it. But in a given case, your lordship may come to a conclusion that it warrants not only investigation by the CBI, but it warrants investigation to be done outside the state. In a given case, if it is to be done outside the state, 226 powers cannot be exercised. One judgment, my lord, to para 89. All right, I leave it to that extent. Therefore, now as far as the
Yes.
ED officials are concerned, my lord, 4 FIRs have been filed against them. Kindly have a look at section 67 of the Prevention of Money Laundering.
Which provision?
67. No suit
Yes.
shall be brought in any civil court to set aside, modify any proceedings or order made under this act, and no prosecution, suit or other proceeding shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. So the search proceedings were done under good faith under this act. Therefore, the prosecution, the FIRs are not maintainable. They're hit by the bar under 67. Despite that, to put pressure on us, these 4 proceedings have been filed. Therefore, I have read separately for stay. Order of stay may be passed, notice may be issued, and the matters may be heard. This is all that I
So we are praying for stay of the FIR against us. The ED officials are facing FIR filed by the local police, my lord. These are, my lord, the FIRs. We have made, my lord, the everments, we have given the details, and we have prayed, my lord, in prayer F, my lord.
Yes.
And they are constantly filing new FIR. So that has been a pattern, we have seen. So page 126 is the prayer clause.
Let us see the prayer. Prayer is
Page 126. Page 126.
No.
E. Capital.
Main matter, page 46.
126. my lord. Main relief. Yeah, not six. Yes. Issue a writ of mandamus directing your lordship wants the entire prayer clause, my lord, to be read, or
Just a minute.
or the interim.
What are your, yes, interim.
Interim is page 126. My lord, where right now, my lord, I would be subject to your lordship, my lord, being persuaded, praying for E. In the meanwhile, your lordship gets direct stay of the FIR number so-and-so registered at Shakespeare Sarni, FIR number so-and-so, and any other FIR registered against any officer of the Enforcement Directorate with respect to the searches conducted on 8/1/26 during the course of investigation of coal scam, etc. So we have restricted our prayer, my lord, to this incident.
What is this past interim direction commanding the respondents to preserve, deposit, and provide a CCTV cameras, a store?
Yes, my lord, that should be preserved, my lord. Let it be with the registrar of this court.
No, right now you are praying for E only.
E. But, my lord, if, my lord, your lordships are persuaded, my lord, C also, my lord, A. Interim directions commanding the respondent to preserve, deposit and provide the CCTV cameras and storage devices containing the footage of both the premises search on 8/1/26 as described, and not to make any deletion.
Yes, take. In these two writ petitions, referred by the Directorate of Enforcement. Oh, yes, in the first writ petition, the petitioners are Directorate of Enforcement and its Deputy Director. Whereas in the second writ petition, the petitioners are
They're the assistant directors and the persons who are party to the search, and they've been named in the FIR as accused.
are the officers of the Enforcement
One is
Directorate.
the IO of the case.
Enforcement Directorate against whom?
Nobody is named. I'm sorry, nobody is named.
Huh?
So they are not named, but they would be.
They went for the search, and the officers who conducted search without naming them are the FIR.
Who had gone to the premises, subject premises, in course of investigation conducted by the ED. Learned ESG, appealing for the petitioners, would draw our attention to the series of events which has led to the filing of the present writ petition. According to him, the ED was investigating a scam amounting to rupees 2,742.32 crores since the year 2020, and in course of the investigation of the said scam, intelligence was received that about 20 crore of proceeds of crime from Calcutta to Goa was transferred through R. Kantilal firm, and which has eventually channeled into I-Pac's operational framework by being handed over to persons executing its work. Armed with authorization to carry out search and seizure proceedings at the residential premises of Mr. Prateek Jain of I-Pac, the officers visited his premises on 8/1/2026. Visited his premises, comma, amongst other premises, comma, on 8/1/26. And when the search was going on, the Manoj Kumar Verma, IPS, the Commissioner of Police, Calcutta, first entered the premises. Dr. Sri Priyabroto, IPS, Deputy Commissioner of Police, comma, Sri Manoj Kumar Verma, IPS, Commissioner of Police, Calcutta, entered the premises, and thereafter, the second respondent in WP number so and so, the sitting Honorable Chief Minister of West Bengal, Ms. Mamata Banerjee, also entered the premises despite making categorical request for not interfering with the ongoing search proceedings under PMLA. He would submit that this is not the singular incident where Honorable Chief Minister has entered the premises under investigation by the ED, under investigation, comma, as on an earlier occasion when the CBI was investigating an offense, the similar event has happened. Therefore, there is a pattern of interference with the investigation carried on by the central agencies. According to him, comma, the materials collected by the ED officers were taken away by the respondents in an illegal manner. And thereafter, the West Bengal police have registered FIRs against the officers of the Enforcement Directorate. Now, SJ would submit that in a situation like this, comma, it is difficult for the central agencies to carry on investigation which has connection with a huge scam running into so and so, 2,700 so and so crores. Pushed up. Learned Counsel would submit that true it is that the petitioner ED has preferred a writ petition before the Calcutta High Court, but when the matter was to be taken up for a hearing on 9/1/2026, the legal cell of the Trinamool Congress sent message to its member on WhatsApp calling them to assemble in the court. And thereafter, what has happened in court has been recorded by the learned judge in its proceedings dated
page 121. 121. Order is
dated 121, which is reproduced here under. Post up. Para. On the above basis, Learned Counsel would submit that Learned SJ would submit, firstly, that the present is a serious matter which needs to be examined by this court, and secondly, the High Court is not allowed to proceed further. According to him, comma, since high police officials of the state government are involved, comma, it would be appropriate for this court to examine the issue in the larger interest of justice and to set and full stop. Learned ASG Sri S.V. Raju, appearing for the petitioners in the other writ petition, would submit that recording of FIR in a cognizable offence is mandatory in view of the law laid down by this court in Lalita Kumari 2014 volume 2 SCC page 1. According to him, when the Honorable Chief Minister and the Director General of Police are involved in the matter, it cannot be expected that the police officers subordinate to them would conduct the investigation in a fair manner. He would submit that the present is a case where the offences committed by the respondents should be investigated by the CBI. He would next submit Sri Kapil Sibal, learned senior counsel, appearing for the respondent number 2 in first writ petition, and Sri Abhishek Manu Singhvi, learned counsel, appearing for the respondent number 1 and 3.
Yeah.
1 and 3 would submit that the present petitions are not maintainable. He would submit that there is a pattern of interference by the ED in the name of investigation exactly at the time when elections are due. They would submit that when the matter is pending in the High Court, the present petition under Article 32 of the Constitution of India may not be entertained. Taking us to the materials on record, particularly the Panchanama, available at page 66, it is pointed out that nothing material was recovered during the search and the seizure. It is also argued that the local police officials were not informed by the ED before initiating the search in the morning of 8/1/2026. Sri Sibbal would particularly submit that the respondent number 2 had not gone to the place of incident in the capacity of the Chief Minister, but C, being the chairman of Trinamool Congress, had gone there on information that certain unauthorized persons have entered into the premises of Mr. Pratik Jain, who has been entrusted with party's election work. According to Mr. Sibbal, there was nothing available in the office of I-Pac except some election-related documents with which ED has no concern, and they should not have entered the premises. Sri Sibbal would also submit that the respondent number 2, being the chairman of the TMC West Bengal, it's a national party, by TMC, is a jet protectee is also a jet protectee. This is your argument. Ms. Singhvi will submit it. Singhvi will submit. So it is a jet protectee. Therefore, it was the duty of the Director General of Police to accompany her when she entered the premises of Mr. Pratik Jain. Sri Shyam Devan, learned senior counsel, appearing for so and so, correspondent number 4 and 5, would argue that when the that it is factually correct that some untoward incident happened when the High Court proceeded to hear the matter on 9th January, but thereafter, on 14th January, the matter proceeded peacefully but has been adjourned at the request of the ED. Therefore, this court should wait for the outcome of the proceedings pending before the High Court. Having heard learned counsel for both the parties, we are of the prima facie view that the present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and its interference by state agencies. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that the offenders are not allowed to be protected protected under the shield of law enforcing agencies of a particular state. According to us, larger questions has been raised and are involved in the present matter, which, if allowed to remain undecided, would further worsen the situation. There will be a situation of lawlessness prevailing in one or the other state, considering that different outfits are governing at different places. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, the question arises as to whether in the taking shield of its party activity, the agencies can be obstructed in carrying out their investigating power in a bona fide manner. Issue notice to the respondents. Let counter affidavit be filed within 3 days. Can you file it within 3 days?
Not possible.
Within a week. within a week.
It's not tough, at least 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we'll preserve all the material. If it takes longer time because the digital
Not
evidence.
preserving, Maharaj, your losses make
Yes.
no issue on that.
Yes,
Uh,
in 2 weeks.
2 weeks.
Post the matter on. Today is 15. Post the matter on 3rd February.
Lord, prayer A and E.
Full stop. Full stop. In the meanwhile, it is directed that the respondents shall preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8/1/26 as described in the writ petition, and the CCTV cameras and storage devices containing the footage of nearby areas. Now, what it is to this? No, investigation. And the CCTV 8/1/26 full stop. It is also directed that the further proceedings and the investigation relating to FIR number 3/26, 4/26, and 5/26 registered at electronic.
There is one more, 7 also, my lord. I have placed on record.
It is there in the main petition, but not here.
In the additional document, it was filed subsequent.
7/26 registered at electronic PS, Vidhan Nagar.
No, no, there are 2 from Shakespeare Sarni.
Just name the police station properly.
No, no, it's in E. E has, my lord, the police station, page 126 E. 2 are, my lord, from Shakespeare Sarni, and 2 are from electronic PS Vidhan Nagar. The index, my lord, in the present.
In just IA.
Yes,
Direct
it's a document compilation.
is also direct that FIR number 3/26 and FIR number 4/26 registered at police station Shakespeare Sarani, and FIR number 5/26 and 7/26 registered at Electronics Complex PS shall remain state till the next date of hearing.
Or any other FIR pertaining to this.
So we may not be aware of.
This is
We
not
do
like
not
a
know.
blanket order.
There should be clarity in our order.
Yes,
You can't
sir.
say that any other this
No, no, I understand.
is not proper.
Great.
Whereas I have one request, just Lordship considering. Whereas normally a Lordship does not stay investigation. No coercive steps will be taken is an alternative.
No. You see, in
Investigation.
view of section 67, if they were armed with a letter of authorization, they were acting in good faith.
I'm only saying, well, investigation without any coercive steps.
Mr. Singhvi, you
No.
understand the delicacy of the matter.
But equally, well,
If you proceed,
both sides.
if you proceed with the investigation in any manner, then
Without
it will be
any
difficult,
coercive
but
steps.
then we will.
Without any coercive steps.
No, my lord,
In any manner.
that may not.
Secondly, Willis, if your Lordship is granting a stay on investigation, then let us have more time to reply, Willis, because then there will be a complete stay on investigation. Let us take out all.
No. 15
There has
days
to
is
be
enough.
more.
What more you want?
Willis, maybe 3
In fact, this
more.
order could have been passed after 10 minutes of hearing. We indicated to you that we are inclined to issue notice. But since both the parties have raised that much of argument, it is necessary for us to record also.
Yes,
Because
be a little
Nowadays it is aired, everything.
now
And
that
then
it is,
everybody will say that court has
Now
not
that it is
recorded anything,
stayed,
so much was argued.
now that Lordship has stated, little more time can be given. That's
Yes, next case.
My lord, the IA for addition of party, for Chief Secretary and others are being joined. And prayer for
Chief Secretary.
suspension. No, suspension power is with the chief secretary.
That's suspension.
That's my prayer. That's my prayer.
We file a counter.
That's my prayer. Manoj.
Let's
Strongly opposing this kind of running of
Notice may be issued.
let counter to IA number so and so
But yes,
may also be filed.
yes, yes.
It's not even listed, Malaj. It's not even listed.
No, it's given, Manoj. Copy is given.
It's
That
got.
I have tendered
These
it.
are the strange
You
procedure.
kindly list it tomorrow, Manoj.
Whatever
Let
it
them
is.
file a reply. I may not get the relief today.
That's not.
You only file counter. We are not saying anything. No passing
Yes.
no orders on that.
We'll file.
Passing no orders on that.
Malaj, if we filing counters in applications, then the main matter, Malaj,
There are only two main matters.
There's so many matters there.
No, only one matter in application.
Let's let counter to IA number so and so. Which are those IAs?
We'll give the number.
It's not
We
numbered.
file before the next date of it.
Yes.
Yes, next.
Item 28.
Right.
हमारे notes का इस production है.
G.
20 corrected. 20 is connected.
Huh?
20 is connected.
Yes.
It says something must.
29.
Yes, next.
Well, it's in this matter, this is for anticipatory bail. Now, he has no criminal antecedents whatsoever.
You impersonated this.
That is the allegation on the basis of statement which is made in police custody. Now, between
You have said in one of the ground
yes,
that settlement agreement
that's right, my lords. We
has
can
been entered into family members of other person with the complainant.
that is on record at page 60. So the money has now been given to the vendee.
Yes.
Page 60.
On the ground of settlement.
Yes. Okay. Ms. Tika Devadi, learned counsel for the petitioner, who submits that the petitioner was not named in the FIR, and as a matter of fact, in matter of fact, which is that page?
Page 60.
No, 60 is something different. Bail application is that agreement.
Page 44. Sorry, I'm so sorry, my lords. The settlement agreement is at page 44.
As a matter of fact,
Okay. In council का नाम, the only council petitioner would submit that petitioner was named in the FIR, and as a matter of fact.
and as a matter of fact, the complainant and co-accused persons have already entered into a compromise, and the entire amount in question has been refunded to the complainant. Issue notice returnable on 10th February. In the meanwhile, petitioners shall not be arrested in relation to crime number so and so, police station so and so, offences under section so.
Very good.
Yes,
What should pass over? madam?
pass over.
Item 1.
Wait, please look. But at the time of issuance of notice, your lordship had directed me to first surrender not, then granted specific liberty to file for suspension. And this is
Yes, Mr. Sharma, this is an offence of 1992.
That's correct, my lord. I understand that situation.
Now, after 1992 means 36 years, he sought to be arrested, needs to be examined. Listener, considering that the offence was committed on 29/8/1992, that is more than about 36 years back. And presently the petitioner is in jail from 18/8/25 after his surrender before the trial court, we are inclined to suspend the sentence and release the petitioner on bail.
Lordship may say in the facts of this case, my lord, because he has not undergone even 1/4 of the sentence.
Therefore, considering the facts and circumstances of this particular case, we are inclined to suspend the sentence and release the petitioner on bail. Accordingly, it is directed that on petitioner's furnishing, therefore, it is directed that petitioner shall be released on bail on such terms and conditions as may be imposed by the trial court.
Deeply well. Very good.
Post the matter. Records have been summoned.
No, my lord, not yet.
That record of the trial court be summoned and the matter be posted. The matter be listed on 6th April.
Very deeply well.
Grateful, my lord.
Yes,
Lords, at passed over item 5.
Need the lordship.
pass over.
Yes, this is that matter where the cost.
I went for the,
Only about cost.
the notice was issued to the limited aspect.
Yes, yes. Leave granted.
Yes, sir.
Well, under the impugn order, the High Court has quashed the notice issued by the additional district magistrate Hapur in so and so ये अपने order में लिखा हुआ है 28/11/25 plot. There are two matters.
Yes, no, same, exactly the same order has been passed.
ये देखिए दो केस नंबर लिखा है, एक एसएलपी का एक केस नंबर है, एसएलपी का दूसरा केस नंबर। ये कॉमन ऑर्डर है ताकि दोनों का एक साथ लिखिए। अच्छा, दोनों का कॉमन ऑर्डर ही बनाओ। कॉमन ऑर्डर so and so in case number so and so, full stop. While quashing the notice under challenge before the High Court, comma, a cost of rupees 20,000 has been imposed on the state of UP in each of the case, further reserving liberty in favor of the state to recover the same from the concerned additional district magistrate. Well, having examined the matter, we do not find that the High Court has recorded any finding that the concerned magistrate has passed the order which was under challenge before the High Court in modified exercise of power or due to any extraneous consideration. In such view of the matter, comma, imposition of cost of rupees 20,000 and directing the same and reserving liberty in favor of the state to recover the same from the additional district magistrate is not justified. Accordingly, we quash the said part of the impugn order imposing cost of rupees 20,000 on the state.
What's the question of law and that would be left open in other matters also because that would
We have already dismissed that part. That part is already covered in our order issuing notice.
Very well.
Yes.
Deeply aware.
Am I audible?
This sort of pass.
Yes.
Malas, am I audible?
Yes, yes.
Malas, this is a transfer petition where a wife who is based in Kanpur and she's seeking a transfer of the Section 13A petition from Gwalior to Kanpur, Malas, which is approximately more than 300 kilometers far. Now, Malas, also see Annexure 4 of my petition, Malas. There was a different matter way back in 21 involving the similar parties, in fact, same parties, which was also transferred to Kanpur from Gwalior. Annexure 4, Malas.
Page?
Malas, page 38, Annexure P4. This is the order of the Supreme Court, Malas.
is our order. Then let it go to the same place.
Manoj,
Yes,
there are a
Manoj.
few submissions in this matter.
Yes.
Prior to the mediation, we were informed that they are willing to settle the matter. We took the matter into mediation and
Manoj.
they informed us that they would be willing to settle
Manoj.
with the amount that we stated. Right? We stated that the settlement should be arrived at an amount of 10 lakh rupees.
Manoj,
Now
they
increase
never
that
offered
amount,
10 lakhs. They
went
initially
to
offered
30.
18 lakhs.
The child is in all.
Just 1 minute.
They've now increased that amount. They went to 30 lakhs just to settle the matter. Now they also have the custody of the child. I am paying why the order dated why an order dated.
This is only a transfer petition.
This is
Yes,
a
my
transfer
lord, but
petition,
they're
Manoj.
seeking to harass us in the mediation.
Manoj,
While
this is
the
very
mediation
unfortunate that a
was going
man
on, they
who's
kept
so
on saying that there
self-centered,
are more cases which
he's
are about
hardly
to come.
bothered about his son, Manoj. He's not ready to pay anything. We offered him to create a
Manoj, I'm
FD for his
paying
son. He
maintenance
refused.
since 2024. That
He's not
maintenance
willing to pay
amount
a
has also
single penny
increased.
for
They
his
have the
child,
custody
Manoj.
of the child.
Considering that on an earlier occasion, this court has allowed petitioners TPC number 2840 of 22 and transferred HME number 543-A of 2020 from Family Court Gwalior to Family Court Kanpur City, the present transfer petition deserves to be allowed so that the cases pending between the parties are tried at Family Court Kanpur. Accordingly, the present transfer petition is allowed and so the prayer class is transferred. Yes.
Much obliged, Manoj.
Item 14.
Yes.
This is a transfer petition filed by the mother-in-law, husband, brother-in-law.
Mother-in-law. Transfer petition by mother-in-law. Deviate.
We all are the petitioners here. Husband, brother-in-law, mother-in-law, age 80 years, and sister-in-law, and a relative is 71 years.
It is from Visakhapatnam to Mumbai.
Please, Lordship. More importantly, that the
why deviate proceedings initiated by the wife should be transferred to a place where the husband is residing?
No, but Lordship, my problem is that kindly see page number 56. We are represented by the lawyer there, but the court learned ACJM.
Court wants you to appear. You appear, husband. Others may be exempted.
That's all.
So I have no problem so far that is concerned. This transfer petition appears to be filed on a premise. They appear to be aggrieved only by the reason that they've been asked to appear personally. Because if that is the grievance, they have a remedy to file an appeal. Because there is no other ground stated in the transfer petition for seeking transfer. But I stay in Visakhapatnam with my 4-year-old daughter, Manoj. It is not possible for me to travel.
We can
and 498A trial is already going on there. They are appearing there. They are appearing in this one also through their lawyers.
On hearing learned counsel for the parties, we are not inclined to allow the transfer petition seeking transfer of the proceedings under the Domestic Violence Act initiated by the respondent wife. However, we direct that the trial court, that is the 4th Additional Chief Judicial Magistrate, Visakhapatnam, Andhra Pradesh, shall not insist on physical appearance of the respondent.
Well, let's consider saying the other respondents. So the husband can appear, the other respondents will be exempted, subject to what my lord speaks.
Respondent of the relatives of the husband.
That's right.
Unless their physical appearance is mandatory on any particular date of hearing.
Lordship, they can join through VC. Lordship.
That's what my lords have said.
The relatives of the husband shall appear through video conferencing on such dates where their physical appearance has not been directed by the.
Grateful, absolutely.
Yes.
Great.
Item 21.
But this
Yes,
this petition got caveator is present here. It was passed to
caveat,
caveator is present
eviction,
of from a shop lot in Delhi.
market,
Please, Your Honor.
Khan market.
450 square yards.
2017 eviction, 18th March 2017, and you are resisting.
No, I'm not resisting, my lord.
Then
There's
who is
a-
resisting?
I'm not resisting. I just filed a revision. That's all. In the Delhi Rent Control Act, there is no provision for an appeal.
Means resisting in a legal way.
Yes, ma'am. That way.
Not physically.
Not in any other way.
Yes, yes.
Not under the Delhi Rent Control Act, there is no appeal.
Time, how much time?
No, Your Lordship, just allow me.
You say there was an oral agreement
No.
to sell.
My Lord, I've got the material.
Honoring his oral agreement for last so many years.
The material is
Not
there on
telling it
record.
to the person with whom he has oral agreement.
Lord, may I just His Lordship, just allow me about 2-3 minutes, and then I won't take a Lordship more below that. Lordship, I'll just refer to my written statement where I said so that all these facts that they had agreed to sell this property to a person through so and so. In the replication, they admit it. They admit that they were dealing with this man, but they changed their stance and they said this was only to in order to enable him to change the nature of the property from leasehold to freehold. This is their stand.
See,
When the document comes, the document comes, it says permission to sell. I just point that to your Lordship. P2. Lordship may just have P2. Lordship may have P2, and then I'll also. It is permission.
Page?
Lord, P2 is at page 68. Page 68. Lordship may see the title of this. P2, page 68. Permission for sale of shop number 30A, Khan Market. So what they say eventually when he comes in cross.
2010.
Yes, brother. But this is during pendency of the rent petition.
And
This
you
is
are a tenant since?
Since 1975.
Then it will happen. Out of frustration, the landlord will.
No, my lord. It's not out of frustration. When they gave it to me, that was a market rate. It's a different matter. Market forces have changed. It's a different matter. Now I'm paying 2.5 through court.
It always happens. The
I'm
landlord feels after 15, 20
I'm paying.
years.
So here they want to sell it. Then come, Lordship may allow me to refer to.
You see, this particular area,
Yes.
it is the costliest
Yes.
in the Asia, or I do not know where. Some news I have read.
Yes.
This Khan market.
Lord, now it at one time it was. Now it seems to have lost its sheen. This area has lost its sheen now.
It has not lost its.
It's only now a eating place where everybody goes for their restaurants, more restaurants
I
than.
do not know whether it is eating or something else.
It's more like that now.
But it is
Market
very
is
popular.
famous for that.
It is very popular.
Yes, sir. Therefore, he wanted to sell
For
it.
multiple reasons, it is popular.
Therefore, my lord, the idea was to sell it. And now, unfortunately, under this act, my lord, this is a strange act. It doesn't even have a provision for an appeal. There's no provision.
The only ground
Yeah.
to issue notice in your case is that Mr. Siddharth Dave is appearing
That is good enough, Lord.
for the landlord, leaving all his bail matters and legal matters.
That's why I had to take a pass over. I'm very sorry, man.
And my lord, a caveator got a pass over. That's good enough reason. We've all been waiting. Lordship may.
Same time, 6 months, 8 months.
Lord, statutorily there are 6 months. The court says I will not even grant you that. Please leave immediately.
2017, you were allowed 6 months.
Lord,
Several 6 months have
Lord,
gone
after that I had a right to file a revision. There was a stay order in that revision, and then I've been paying money as per the market rate.
Now we can allow further 6 months. We can allow further 6 months from today.
Lord, could your lordship just consider increasing that amount of days? Why? Because it's a shoe shop. I have to sell off
Amount
of the time.
No.
I have to sell this entire material there. I have to sell this entire material. I'm not shifting to another place.
And
I will shut down the business.
He owns the shop which is next to it.
Money will not.
Next to this shop, he owns a shop which is let out for 8 lakhs of rupees. And I am 2.5 lakhs. He has to shut down his business.
Not.
This is not fair.
There's nobody ready to take on
At
the
least
business.
my learned friend should be fair.
Upon hearing learned counsel for the petitioner and learned counsel for the editor, we are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, considering that the subject premises is a non-residential premises, we allow the petitioner to occupy the same for a period of 6 months from today. Accordingly, the SLP is dismissed and the petitioner is directed to hand over vacant possession of the subject premises on or before today is 15th, on or before 16th of July 2026.
He can pay that amount.
Petitioner shall file usual undertaking before the registry of this court and also continue to pay the monthly rent
It was fixed as user charges, my lord.
user charges
As assessed by the High Court one.
as assessed by the High Court. Yes, next.
I'm grateful.
Would your lordship consider 2 months more, Lord? We have to sell this stock.
What you will do in 2 months?
We have to sell this. Not this is all shoes which I bought from people.
Yes,
we have to sell them.
Miscellaneous matters completed.
Miscellaneous completed. Regular matter will not take. We are not taking up.
One small request. One small request in 101.
Yes.
Just a small request in 101, my lord. Lords had directed us to file one of the deposition which was not filed by us. But there has been some technical glitch we have not been able to file. Carrying up. My lord, may kindly give me fresh direction so that I file that in the counter physically.
Both of them are so happy when he said these two.
Okay. Lords had a marathon, lords.
Yes.
So, my lords, I need fresh directions from my lords to file that additional document, my lords, because my lords.
Fresh direction? When there is a one direction,
no, lords, the time expired, my lord. There was some technical glitch carrying a printout. So it says that the matter is.
Item number 101.
Yes.
You for the petitioner.
Yes, appellant.
101 million. No, petitioner is allowed 4 weeks time or 2 weeks.
2 weeks, lords. We are ready with that
to file additional documents
and written submissions.
Post after 2 weeks.
But,
my lord, deeply
obliged. 102. It's a very, very short matter. It retains position a lot in the coming week.
For the respondent in this matter,
102 is a very short matter. Will it retain its position in the coming week?
I just if you not taken up, it will automatically be repeated.
My lord, I have a small request in 103. Instead of the next week, it could come in the week on 28th or 29 January. Grateful, man.
Thank you. अरे किसी को बुलाया
नहीं आया कहीं